This squarely applies to any person who belongs to LGBTQ community and he wants to marry a person whom he likes or she likes. So the question Dear students, hello and welcome to another lecture. And the topic of this lecture is one of the landmark and the most important judgment of the Supreme Court, Supriya Chakrabarti versus Union of India. The story behind this is that the Indian Constitution contains various parts, and one of the most important part in the Indian Constitution is part 3rd of the Constitution, which contains the fundamental rights of the people. These fundamental rights is what makes democracy a democracy. And one of the most important articles within part 3rd is Article 14, Article 19 and 21, which are said to run like a golden fabric or golden thread across the fabric of the Constitution. The question is that when we talk about Article 14, we talk about equality. The state shall not deny to any person equality before law or the equal protection of laws. And in the light of this, it all started way back in 2009 when a Delhi-based NGO, NAS Foundation, an advocate for the rights of LGBTQ, lesbians, gays, bisexuals, transgenders, and queers. The question was that since it is an advocate for the rights of the LGBTQ community, it wants to get this decriminalized through a petition before the Delhi High Court. In NAS Foundation, as an NGO, it filed a petition before the Delhi High Court challenging Section 377 of IPC, which criminalized sexual intercourse between two consenting adults of the same sex, and which also mentioned punishment. So these gays, lesbians, bisexuals, transgenders, they were all criminals if they commit any such act, if they enter into any sexual intercourse of with the same sex, then they are going to become criminals in the light of Section 377. NAS Foundation filed a petition before the Delhi High Court, and the Delhi High Court struck down Section 377 of IPC as unconstitutional, as being violative of Article 14, 19 and 21. Article 14, 15, 19 and 21. Because it was against the principles of equality. It said that just like the way heterosexuals are made to live freely in the society and they have a free choice to marry anyone whom they like, why shouldn't be the same thing apply for the homosexuals in the society? But later, when this judgment of the Delhi High Court was challenged before the Supreme Court in Suresh Kumar Kaushal versus NAS Foundation and others, the Supreme Court in 2014 it overruled the judgment of the Delhi High Court, and observations kept aside the observations of the Delhi High Court and said that it was not a violation of equality. Section 377 was again criminalized by the Supreme Court when the Supreme Court mentioned it very clearly that it is not a violation of the Supreme Court. The comparison made between the heterosexuals and the homosexuals is absolutely wrong. It has no base. It is completely bogus, because the doctrine of reasonable classification, which is enshrined within Article 14, is based on making or classifying the society into different groups based on intelligible differentia. And intelligible differentia means that you have to classify your group on a certain ground, and then you have to make a law. If we are comparing heterosexuals with the heterosexuals, then it can be a good comparison. If somebody from the LGBTQ community, for example, lesbians are made to become the criminals while gays are completely absolved from these things, or transgenders are given a certain form of punishment while the bisexuals are left alone, are left away from the punishment, then that is going to be a violation of equality. Okay, but since LGBTQ community is just one community, while the heterosexual community is another community. Comparing these community with this one is completely bogus. It is completely baseless. Equality has to be ascertained within one community. Okay, so this is what the Supreme Court said in 2014. But the same Supreme Court in 2018 in Navtej Singh Johar versus Union of India decriminalized Section 377 and legalized homosexuality in India. That was yet another reportable judgment which created a lot of hope in the LGBTQ community, within the LGBTQ community, because the Supreme Court legalized the sexual intercourse between two consenting adults of the same sex. Henceforth, after 2018, it was not a crime to have a sex to have a sex with the person of the same sex. Okay, to have sexual intercourse with a person of the same sex. A man can have sex with man, a woman can have a sex with any woman. So that was no more a crime. After the Supreme Court's judgment in Navtej Singh Johar versus Union of India on 6th September 2018, it was no more a crime. But now the question in this case is that why not there should be legal recognition of the gay marriages or the lesbian marriages or homosexual marriages. See, having sexual intercourse and decriminalizing it as an act in terms of equality is something different, while recognizing the marriages between the same sex is something absolutely different. Now the question before the Supreme Court in this case was that if two consenting adults of the same sex they enter into a marital relationship, this marital relationship this marital relationship should be legally recognized. See, when a person marries, if A has married B, like obviously they are a boy and a girl, A has married B. A is a boy, B is a girl. If A has married B, then their marriage has to be registered with the government of the state. The state is going to give them, after due registration, the government is going to give them a certificate of marriage to ascertain that they are legally married in the eyes of the law of the land. So, after you attain this certificate, you become legally married in the eyes of the law of the land, and your marital status changes on your documents. And once your status changes, you become, you enter into another category of married people. And when you enter into that category of married people, you are liable for certain things. Like, for example, you are now subject to the laws of bigamy, which is a crime. You are now subject to certain schemes which are for married people. You are not subject to various civil laws which are for married people. There are certain laws. Once you will get into this profession, you will get to know that there are certain things which are exclusively for the married people. So that is why the registration of the marriage is important. You get your marital status changed on passport because you are now married and you want to take your spouse to another country. If you are working somewhere in Canada or United States, what do you have to do? You get you have to get your marriage registered so that you can get your marital status changed on your passport and other documents and can call your spouse to that country. So this is just one example. This is just one example I'm telling you. Now the petition before the Supreme Court was for the legal recognition of marriage. See, decriminalizing sexual intercourse was something different, and legalizing or legal recognition of marriages or gay marriages or homosexual marriages is something different. The question before this was that now the Supreme Court, after decriminalizing sexual intercourse between the same sex, should now legally recognize the marriages between the same sex, so that people who are gays, who are lesbians, or who are entering into marital relationships with their choices or spouses, they should get their marriages registered and they should be legally entitled to the same things as any heterosexual couple is. Okay. The Indian Constitution does not explicitly recognize the right to marry as a fundamental right. However, that does not shun the possibility of it becoming a constitutionally guaranteed right. The Constitution has been expansively interpreted before, and the right to health, education, etc. are examples of penumbral rights read in within the existing provisions. With respect to the right to marriage and choice of partner, the Supreme Court had developed a progressive and transformative jurisprudence starting from the 2006 case of Lata Singh versus Union of India. The Supreme Court held that the petitioner had the right to choose the partner whom she wanted to marry, and the law does not prohibit intercaste marriages. Now, for example, if somebody enters into an intercaste marriage, or if somebody, an Indian, marries a German girl, or any European girl, or an American girl, or any foreigner, their marriage is going to be registered under Special Marriages Act 1954, SMA in short. Special Marriages Act 1954. This is Special Marriage Act 1954 is for the people who marry outside their caste or outside their religion, for interreligious marriages, intercaste marriages, or interethnic marriages. For example, you are Asian Indian and you marry a girl from Britain, or Britisher girl, or you marry an American girl. Your marriage as an Indian citizen is going to be registered under SMA, Special Marriage Act 1954. The question was that SMA should be broadly read up by the Supreme Court in order to include marriages or spouses of the same sex, belonging to the same sex, so that the marriages between the same sex should be legally recognized in the same way any heterosexual couple's marriage is recognized. Okay. In Justice Case Puttaswamy versus Union of India, while upholding the fundamental right to privacy under Article 21, it was pointed out that vital personal choices related to marriage are included within the ambit of privacy and dignity of an individual. See, that is how. See, why was it decriminalized? Because Supreme Court said it is a violation of equality. Supreme Court said that it is a violation of right to marry, because right to marry was earlier recognized by the Supreme Court in Shafeen Jahan versus Ashokan came, which I have already explained to you in one of my videos. Right to marry a person of your own choice is a fundamental right under Article 21, right to life and personal liberty. Personal liberty includes your right to freely marry a person of your choice. Okay, so once that has become a fundamental right, if that has become a fundamental right, then this squarely applies to any person who belongs to LGBTQ community and he wants to marry a person whom he likes or she likes. So the question was that this was legalized by the Supreme Court. This was legalized by the Supreme Court. It was pointed out that vital personal choices related to marriage are included within the ambit of privacy and dignity of an individual. So right to marry a person of choice, right to equality, and right to personal liberty, these are all the things that together legalize the sexual intercourse between the same sex of two consenting adults. Now, in Shakti Vahini versus Union of India also, the Apex Court adhered to this position. It held that consensually choosing life partner is a manifestation of their freedom of choice guaranteed under Article 19 and 21. Consequently, in Shafeen Jahan versus Ashokan KM, that's what I have already told you, the court stated that the right to marry the person of one's choice is a fundamental component of Article 21. This right cannot be curtailed except through a law that is just and reasonable. So then in Lakshmi Bai Chandaragi B versus State of Karnataka, depended on Shafeen Jahan to hold that the right to marry a person of one's choice is integral to Article 21. Then in Navteej Singh Johar versus Union of India, I've already told you that it said that it struck down Section 377 of the IPC as unconstitutional, as being violative of Article 14, 15, 19 and 21, and therefore sexual intercourse was legalized. Beyond these precedents, India is a signatory to the Universal Declaration of Human Rights. Article 16(1) of the UDHR 1948 stipulates that men and women of full age, without any limitation due to race, nationality, or religion, have the right to marry and to found a family. This is international fundamental right. UDHR is an international document. It is the Constitution of the United Nations. And after the setting up of establishment of the United Nations organizations on 24th October 1945, the international legal minds, they were occupied in drafting a constitution for the United Nations, which came into being in 1948, and on 10th December 1948 it was adopted by the General Assembly as the Constitution of the United Nations, which contains 30 articles. The most fundamental rights of the people of the world are contained there. So Article 16(1) of UDHR stipulates that men and women of full age, without any limitation due to race, nationality, or religion, have the right to marry and to found a family. It recognizes the right to marry as a human right. This right is affirmed by Article 23(2) of the International Covenant on Civil and Political Rights as well. But let me tell you, this is my personal observation here, that this does not contain, see, race, nationality, or religion. This does not contain sex. This does not contain gender, because it is understood that a man is going to marry a woman only. There is no sense made out that a man marries a man and a woman marries a woman. So that is not something which is logically acceptable. Okay, then though the above mentioned cases and international covenants imply a fundamental right to marry, this specific question was never answered by the court. When finally it did, the court reasoned that it is not a constitutionally guaranteed right. It made a narrow distinction between the right to marry and the right to choose a partner, and held that the precedents dealt with the latter, not the former. It also refused to engage with international instruments while deciding this issue. The Indian courts were never hesitant in using international norms to interpret statutory provisions and identify unenumerated fundamental rights. However, in this case, the court selectively referred to these covenants to justify their decisions. Okay. Now the question was, I'm telling you what happened in this case, Supreme versus Union of India. The Supreme Court said, we have already recognized sexual intercourse between two consenting adults of the same sex, okay, as a legal act. It is decriminalized now. There is no point to it. But before granting any legal recognition, by broadly reading provisions of Special Marriage Act 1954 to include marriages of the same sex, marriages between the same sex, is something beyond the jurisdiction of the Indian judiciary. This is not in consonance with the constitutional principles, because granting legal recognition is the job of the legislature. This is a legislative act and we cannot intervene in this area. Legislature ही कर सकता है. देखिए, कानून बनाना ये लेजिस्लेचर का काम है, जुडिशरी का काम है उसको इंटरप्रेट करना. हर बार जुडिशरी इस हद तक इंटरप्रेट नहीं कर सकती, so that it enters the domain of legislation. Legislation is the domain of the legislature. So the Supreme Court clearly stated that in order to recognize the marriages between same sex is a legislative domain. It has to be considered by the legislature. Whatever it thinks with, whatever its policy is, no matter what it thinks and how it does, the question is that it is beyond the domain of the judiciary. Judiciary is sitting here to interpret the laws, not to enter into the legislative domains. So this is the cup of tea that belongs to the legislature. This is not judiciary's cup of tea. The impact of this decision is not just on the non-heterosexual couples, but everybody. Since marriage is not a fundamental right, it will have a significant impact on the pending petitions challenging the freedom to religion, love jihad. Upholding the challenge against the constitutionality of these laws would be more difficult. It is already difficult to get relief in case of intercaste or interfaith couples. This is further intensified when the relationship is queer in nature. Marriage is a significant social institution that the society comprehends. Hence, the judgment determining its legal enforceability holds certain normative value. Normative means what should be. Okay, normative sense means what should be like. There are serious apprehensions regarding the impact of this judgment when it trickles down to police stations, families, etc. Since marriage continues to be the tag for social recognition, the judgment paves way for further discrimination. It would leave an impression that queer couples are not fit for marriage, as the apex court has denied them right to marry. It denies them the rights conferred by the same court through the case of Navteej Singh Johar and leaves their rights at a further predicament. Though the right to marry is not a fundamental right for anyone, its absence would disproportionately impact queer couples. So that is, I have already told you, recognizing legal marriage is not within the domain of the judiciary. It is a legislative domain which the Supreme Court refused to enter into, and it said that the legislature has to consider this question, not the judiciary. Okay, so thank